In this third video in our series on the big picture in constitutional law, I want to turn to human rights. As you know, the question that we're concerned with in these lectures relate to the nature of the British Constitution and the extent to which it is simply a product of whatever forces act on it through things such as legislation, versus the extent to which it is a constitution that sets parameters and has some degree of inherent and perhaps even immovable content. Against that background, the central question I want to explore in relation to human rights is to what extent, if any, is the protection of human rights hardwired into the Constitution? In other words, to what extent is it attributable to innate or inherent features of the Constitution, as opposed to simply being a product of legislation, such as the Human Rights Act, 1998. In exploring that question, I want to outline two contrasting narratives, two different ways in which we might think about the role of the Human Rights Act, and therefore two different ways in which we might think about the Constitution's inherent position as regards human rights. The first of those two narratives views the Human Rights Act as something which has been transformative of domestic law. On this view, we would understand the Human Rights Act as having parachuted in human rights protection. The Human Rights Act, on this view, and indeed human rights themselves, would be seen as something exotic, something that is outside of the regular constitution. Parliament, by legislating, was able to bring this in, but equally on this view, Parliament, by legislating, could just as easily remove the protection of human rights. This narrative emphasises the malleability and ultimately the emptiness of the UK Constitution. In other words, it is of a piece with the blank canvas view that I outlined in the first of these lectures. The second, contrasting narrative, views the Human Rights Act as more reflective of domestic law. This narrative emphasises, for example, that prior to the Human Rights Act, the common law exhibited at least a limited commitment to the protection of common law rights. That common law rights are reflected themselves in the Human Rights Act. And that for this reason, the repeal of the Act, if that were ever to be accomplished, would likely be of limited effect. This narrative, then, emphasises not the malleability and the emptiness, not the blank canvas quality of the domestic constitution, but rather it emphasises the inherent content of the domestic constitution, painting human rights as part of that constitution, not as something that has merely been bolted on, perhaps only for a short time, by means of the enactment of legislation. So by exploring these questions and these two narratives regarding the Human Rights Act, we can better understand both its place in the Constitution and the position that the Constitution itself adopts on this topic. Just to drill down a little further, I want to explore 5 questions that arise out of all of this that will help us to understand how thinking has developed on this point since the Human Rights Act was enacted just over 20 years ago. First, we'll ask whether or not the Human Rights Act effectively puts to one side or even extinguishes common law rights. Second, I'll explain what is meant by the renaissance of common law rights, which is a concept that we increasingly encounter. Third, we'll compare common law and convention rights, that is, the rights set out in the European Convention on Human Rights and given protection domestically by the Human Rights Act, asking, in particular, are common law rights as resilient as convention rights? And I'll explain what I mean by resilience in this context later. Fourth, we'll turn to how we should understand the Human Rights Act's constitutional implications. And then, finally, zooming out to the bigger picture, we'll ask what are the broader lessons we can learn from all of this about the nature of the Constitution itself. Let me begin then with the first of those questions. Did the Human Rights Act effectively put to one side or even extinguish common law rights? Here we can find a variety of judicial reviews and the development of judicial views as time has progressed. A good starting point is the judgment of Lord Coke in the Daly case, a judgment that was given around the time that the Human Rights Act entered into force. Lord Coke took the view that the Human Rights Act is essentially declaratory of common law rights. He emphasised that, in his view, the common law itself is a sufficient source of fundamental rights. He referred in particular in this case to the fundamental right of confidential communication with a legal advisor for the purpose of getting legal advice. But he was speaking more broadly about the common law's attitude to human rights generally. And that's clear from the rest of this dictum, where he says that the truth is that some rights are inherent and fundamental to democratic, civilised society. Conventions, constitutions, bills of rights and the like respond by recognising rather than creating such rights. On this view then, the common law itself is shot through with fundamental rights. The protection of fundamental rights is part of the mission of the common law. And any text, be that a written constitution, a Bill of Rights, or a piece of legislation like the Human Rights Act 1998, is ultimately only declaratory of rights that were already there and that are still there in the common law itself. Quite a different view was espoused by Lord Roger a few years later in the Watkins case. He looked back at cases that had referred to the notion of common law constitutional rights, and he really characterised them as sort of relics of a bygone era. He said that in using the language of constitutional rights, judges had been looking for a means of having the common law supply the benefits of the incorporation of the European Convention without it actually having been incorporated. But now he says that the Human Rights Act is in place, effecting the incorporation of convention rights into domestic law. Now that that's in place, he says such heroic efforts are unnecessary. The convention rights form part of our law because of the Human Rights Act and provide a rough equivalent of a written code of constitutional rights, albeit not one tailor-made for this country. So Lord Roger in Watkins offers a very different view from that put forward just a few years earlier by Lord Coke in the Daly case. Whereas for Lord Coke, constitutional rights are inherent to the common law, and the Human Rights Act is in effect a gloss upon them. For Lord Roger, in the Watkins case, constitutional rights were only ever a temporary stopgap measure, part of this heroic effort at producing a kind of sticking plaster pending the incorporation of convention rights through the Human Rights Act. But once, for Lord Roger, the Human Rights Act was in place, the sticking plaster could be dispensed with, and convention rights could be seen for what they were, things that derived from the convention and really had little to do with the common law. I think it's fair to say that it is the first of those views, it is Lord Coke's view that in general has prevailed. We'll see a number of examples of this later on, but a good starting point is a lecture given by Lady Hale a few years ago entitled UK Constitutionalism on the March. And here she speaks of what we would now refer to as the renaissance of common law rights. She says that after more than a decade of concentrating on European instruments as the source of rights, and she's thinking there primarily of the European Convention, there is emerging a renewed emphasis now on the common law and on distinctively UK constitutional principles as a source of legal inspiration. She concedes that the common law may not offer a prescriptive list of rights, but she goes on to say that this does not mean that it isn't a rich source of fundamental rights and values. So what does this renaissance of common law rights actually amount to? When we talk about it, what are we actually referring to? Well, there are three main aspects, I think, that we ought to have in mind when we use this concept or invoke this concept of the renaissance of common law rights: durability, primacy, and dynamism. First, durability. This concept was referred to by Lord Reid in his judgment in the Osborne case. There, he says that the Human Rights Act does not supersede the protection of human rights under the common law or statute. So what Lord Reid is saying here is that common law rights endure in spite of the Human Rights Act. It may be the case that the Human Rights Act has been a distraction in a sense, in the sense that it has captured our attention and has shifted the focus of attention away from the common law. But what Lord Reid is saying here is that the fact that the Human Rights Act is there, and the fact that it may have stolen attention away from the common law to an extent, should not blind us to the truth that the common law is still there, beneath the surface, beneath the legislative veneer that the Human Rights Act has created. So first then, common law rights are durable, they're enduring, and they do endure notwithstanding initiatives like the Human Rights Act. Second, the primacy of common law rights. Now, I'm not talking here about primacy in terms of are they superior to Acts of Parliament, but I'm talking about where do we look to first and foremost? Where do we look to primarily when we want to understand what domestic law has to say about human rights? Again, we can look at Lord Reid's judgment in Osborne on this point. He said that human rights continue to be protected by our domestic law, interpreted and developed in accordance with the Human Rights Act when appropriate. What Lord Reid is saying here really is that when we want to resolve a question about human rights, the first place that we should look as domestic lawyers is not to the Human Rights Act, but to the common law. Lord Reid doesn't see the common law as some kind of optional extra that we might choose to consult alongside the Human Rights Act, but rather he views common law constitutional rights as the legal centre of gravity. Of course, we might have to look at the Human Rights Act too, but our starting point, he says, should not be the Act, it should be the common law. And then thirdly, the dynamic nature of common law rights. This point is captured by Lord Toulson in the Kennedy case. It wasn't the purpose of the Human Rights Act, he said, that the common law should become an ossuary. In other words, the Human Rights Act doesn't freeze the common law and render it some kind of relic to be placed in a museum, but rather the common law remains as a vibrant, living instrument, something that can continue to evolve, that does continue to develop, and that may develop under the influence, among other things, of the Human Rights Act. We shouldn't therefore be surprised if, for example, we find the common law learning from and absorbing from the influences to which the Human Rights Act and the European Convention has exposed it. So the common law Renaissance view holds that the common law continues to develop, that the common law is the primary source of human rights to which we should look as domestic lawyers, and that the common law is an enduring source of human rights, notwithstanding legislative interventions such as the Human Rights Act. Our next question is, are common law rights as resilient as convention rights? What I mean by that is, can common law rights be protected to a comparable extent to convention rights, or are they always going to be inferior because of parliamentary sovereignty and the status that that implies for the common law itself? Well, let's begin with convention rights. How resilient are convention rights? If we apply a purely domestic law lens, then the answer might seem to be that they aren't very resilient at all. We know that Section 3 of the Human Rights Act gives the courts pretty strong interpretive powers to protect convention rights. The courts have to interpret domestic legislation in line with convention rights as far as it's possible to do so. But we also know, simply by reference to first constitutional principles, that if a court does that, it's always open to Parliament, being sovereign, to reverse that interpretation and to reinstate a version of the legislation that is inconsistent with human rights. We also know that Section 4 of the Human Rights Act gives the courts a power to issue a declaration of incompatibility where it finds that domestic law is irreconcilably inconsistent with convention rights. But it's also the case that Section 4 declarations don't require the law to be changed. They don't require or impose any legal obligation to bring the law into line with the convention right that it has been found to be inconsistent with. In other words, Section 4 declarations of incompatibility sound in the political realm, and they can be ignored if the political capital is invested to hold out in the face of a declaration. However, with convention rights, the picture changes significantly if we view matters not through a purely domestic law lens, but if we switch to an international law lens. Once we do that, we have to accept that the European Convention on Human Rights, to which the HRA gives effect in domestic law, is binding on the United Kingdom as a state. The UK has binding treaty obligations to render its law consistent with the convention rights it signed up to. And in this way, domestic remedies like Section 3 interpretations and Section 4 declarations of incompatibility are in effect invested with a degree of international legal bite. It's all very well to say that as a matter of domestic law, Parliament can reverse a Section 3 interpretation, or Parliament can ignore a Section 4 declaration of incompatibility. Those things are true as a matter of domestic law. But to do those things would be to place the UK in breach of its international legal obligations. And so in this sense, international law, which knows nothing and cares nothing about the domestic notion of parliamentary sovereignty, stands behind and underwrites the Human Rights Act regime. So that when a domestic court issues a remedy under the Human Rights Act, be that under Section 3 through interpretation or Section 4 through a declaration, the domestic court, while not directly invoking international law, is implicitly invoking international law, and Parliament and the government are aware that if they don't play by the rules of the Human Rights Act, if they don't play by the rules of the European Convention to which the Human Rights Act gives effect, then they will be placing the UK in breach of international law. And that means that for as long as the Human Rights Act remains in force, which is an important caveat because, of course, it could be repealed, but that means that for as long as the Human Rights Act is in force, convention rights have a high degree of resilience, because it is not straightforward. once the international legal picture is factored in. It is not straightforward simply to ride roughshod over the convention rights. So much for the convention rights. What about the common law? Well, on the face of it, common law rights would seem to be in a weaker position in the sense that they are always going to be vulnerable to parliamentary sovereignty because acts of parliament take priority over the common law. But for three reasons, we shouldn't be so quick to dismiss the resilience of common law rights. First, we know from many cases that the courts are prepared to adopt a strong approach to interpretation. We saw one example of that in the previous lecture when we considered ouster clauses, and in particular the Privacy International decision. Here we have Lord Steyn in a dictum from the Pearson case setting out a classical exposition of the principle of legality. Parliament, he says, does not legislate in a vacuum. Rather, it legislates for a European liberal democracy founded on the principles and traditions of the common law, and the courts may approach legislation on this initial assumption. He then goes on to acknowledge that the assumption only has prima facie force. It can be displaced by clear and specific provision to the contrary. So what Lord Steyn is reminding us of here is that common law rights have a degree of resilience that springs from the principle of legality, that springs from the court's preparedness to interpret acts of parliament compatibly with common law rights and values where that is possible. And in that sense, this common law principle of legality is sits alongside and bears comparison with the court's interpretive duty under Section 3 of the Human Rights Act. Of course, the difficulty is that whereas the internationally binding force of the European Convention sits behind Section 3 of the Human Rights Act, nothing comparable, at least nothing comparable on the international law plane, sits behind the domestic principle of legality. And that leaves open the question, isn't this still all just vulnerable to a clear and specific provision, as Lord Steyn puts it, to a clear decision by Parliament to override common law rights? Well, that leads on to a second point, to a power of what we might call soft strike down. And this I base on some evidence that Lord Phillips gave to a parliamentary committee a number of years ago. Lord Phillips was talking here about a situation in which a court is presented with a piece of legislation that appears to fly in the face of some fundamental constitutional right or principle. And he's really sort of explaining what it is that a judge might do in these circumstances. He says that there would have to be a constitutional crisis before you could envisage the courts purporting to strike down primary legislation. Note that he isn't saying that courts would never do that, but he's saying this for a court to contemplate it, there'd have to be something pretty extreme going on. Then he says that before the court took that sort of extreme step, that kind of nuclear option of strike down, the court would begin by assigning to the offending provision an interpretation that it could not bear. That in itself is rather an odd concept, giving something an interpretation it could not bear. I think that what he means is that the court will say that a provision means something that linguistically it can't really be taken to mean, in that the court would be departing radically from any natural construction of the legislation. And this idea, he says, of giving the offending provision a meaning it can't bear linguistically would amount to throwing the gauntlet back to Parliament and saying, we've pulled you back from the brink. Are you really going to persist with this? And he says that this is what the House of Lords did in the Anna's Minute case. Arguably, it's what the Supreme Court did in the Privacy International case. This possibility of soft strike down, of not actually explicitly striking down the legislation, but of giving it a meaning that it can't linguistically bear to pull Parliament back from the brink, is a further means of investing common law rights with a degree of resilience. Resilience in the sense that they don't immediately yield to legislation that may seem to conflict with them, but that instead the court will go through this process of attempting to bring Parliament back onto, as Lord Phillips would see it, the right side of the constitutional line. And then finally, there is the possibility, at least we're told by some judges, of actual hard strike down. For example, in the Muan case, Lord Hodge said that he did not exclude the possibility that in the very unlikely event that a parliamentary majority abusively sought to entrench its power by limiting the electoral franchise or a similar device, the common law, informed by principles of democracy and the rule of law and international norms, would be able to declare such legislation unlawful. So Lord Hodge here is contemplating the possibility that in extremis, in really extreme circumstances, the courts may proceed beyond the kind of thing that Lord Phillips described and which I called soft strike down, and that they might engage in an actual, explicit, hard strike down, where a court simply refuses to give effect to an act of Parliament on the ground that it is inconsistent with fundamental constitutional principles. If that's true, then common law rights have a very high degree of constitutional resilience. Indeed, they appear to have a higher degree of constitutional resilience than their convention counterparts, because ultimately the Human Rights Act can be repealed and the UK can be taken out of the European Convention on Human Rights. If Lord Hodge is correct, then common law rights are resilient to a greater degree than that, because on his view, there are certain constitutional rights and values that are so deeply embedded in the Constitution that there is no possibility of courts accepting legislation in breach of them. Now, there's a big if around all of that, because, of course, a court has never done what Lord Hodge says a court might do. But if Lord Hodge is correct, then that has significant implications for this question about the resilience of common law rights and about their relative resilience, relative, that is, to convention rights. Let's move on then to our penultimate question. How should we understand the Human Rights Act's constitutional implications? Where does it fit into our Constitution? And what in turn does that tell us about the Constitution? On one view, we might see the Human Rights Act as something that is quite exotic to the Constitution. In other words, as something that is of another place, that brings something of that other place to the domestic constitution, but that could equally be taken away again, just as it was first imported. And certainly, there are senses in which the Human Rights Act seems to bring into effect quite a different approach to human rights protection, different from that which applied at common law. Traditionally, the common law has reasoned in terms of residual liberties, that we are free to do those things that Parliament doesn't prohibit, whereas the Human Rights Act introduces a catalogue of positively articulated rights. The Human Rights Act brings into play, to a much greater extent than it applied before, the notion of proportionality in place of the domestic concept of Wednesbury reasonableness. the Human Rights Act did away with the need to find that law was ambiguous before convention rights could be relied on as aids to interpretation. Section 3 now requires all legislation to be construed compatibly with convention rights whenever it's possible to do that. So there are certainly changes that the Human Rights Act has made, and I think it would be naive to argue that the Human Rights Act has done nothing more than codify existing practice. It's clear that it has changed practice. And if we focus on those points, then we would tend to view the Human Rights Act as something that has been transformative, that has changed our constitution and changed that constitution's approach to and characterisation of human rights. We would see it as exotic, as something which has brought in a different approach, but we would also then have to concede, perhaps, that it's reversible. That just as the Human Rights Act could be enacted and could instantiate these changes, equally, the Human Rights Act can be repealed and those changes can be reversed or taken away. But there is also a different perspective that we ought to bear in mind that focuses not on points of distinction but on points of contact. Those points of contact include the fact that the common law did acknowledge fundamental rights prior to the Human Rights Act's enactment. Not to the same extent and not in the same way, but certainly the common law was not ignorant of the notion of fundamental rights. We can go further. Some rights had strong protection prior to the Human Rights Act. If we think about the kind of right that is in effect in play in a case like Anna's Minnick, we see the courts conferring a very high degree of protection. Indeed, the approach to the interpretive protection of rights that we see in a judgment like Anna's Minnick arguably goes further than the degree of protection that is accorded to rights under Section 3 of the Human Rights Act. And thirdly, another point of contact is the degree of constitutional resilience that common law rights have. It's possible to paint a picture in which common law rights are the poor relations of convention rights in this regard. But for the reasons that I explained earlier, common law rights do enjoy a degree of constitutional resilience, and arguably, if we press Lord Hodge's logic to its endpoint, arguably an even higher degree of resilience, at least in extremis. On this narrative, the Human Rights Act may be seen not as something which is exotic and transformative, but rather as something that is evidence of the common law's own potential. On this view, the Human Rights Act, although it has introduced changes, is not the sea change that the previous narrative implies. Rather, there's a greater degree of continuity, there's a greater degree of contact between the two approaches than the other narrative allows. Looked at in this way, it's true that the Human Rights Act has emboldened the courts in certain respects. The courts now protect a broader range of rights. In some instances, they will go further in protecting rights, whether that's by adopting bold interpretation across a wider range of rights, or in terms of relying on more demanding concepts, such as proportionality. But once we put to one side this idea that the Human Rights Act is this sort of exotic bolt-on which can be just as easily sheared off, we might then have to accept that the emboldening effect that the human rights has had may survive its repeal. If the Human Rights Act were to be repealed, we shouldn't therefore expect the common law to snap back to its pre-Human Rights Act position. We may rather expect the common law to have absorbed things from the Human Rights Act, and for the common law post-Human Rights Act to go further in terms of protecting rights than the pre-Human Rights Act common law did 20 or so years ago. And so this tells, I think, quite a complex and rich story about the interaction between the legislated for aspects of the Constitution and the inherent aspects of the Constitution. The Human Rights Act is a legislated for aspect, and it has clearly made significant differences. But it's also something that can operate on the inherent aspects of the Constitution. And we shouldn't be surprised, therefore, that if at some point in the future the Human Rights Act were to disappear, it may have left an imprint on the common law, and that the common law may be the stronger for it. Finally then, what broader lessons can we learn about the Constitution through this comparison of common law and Human Rights Act rights? Well, we can go back to our contrast between the flexible and the durable views of the Constitution, one of which sees the Constitution as ultimately malleable and essentially a blank canvas, and the other which sees the Constitution as having innate content that might be resilient to interference. In relation to the flexible view of the Constitution, we would ask, was it really a blank canvas when the Human Rights Act was enacted? And the answer is surely that it wasn't, in the sense that common law rights were there to begin with. Should we view the Human Rights Act as having painted over common law rights and effectively displaced them? And again, the answer would seem to be no. We're told by Lord Reid, for example, in Osborne, that common law rights are enduring and that they have not been displaced by the Human Rights Act. So again, that would support this narrative that the Constitution in relation to rights is not inherently flexible, and that it does actually have real, substantive, enduring content in the form of common law rights. Finally, the flexible view of the Constitution would suggest that common law rights would lack resilience in the face of legislation. If we associate the steamroller of parliamentary sovereignty with the flexible view, in the sense that it's for Parliament to decide what goes, and whatever Parliament says is the end of the matter, then we would expect to see common law rights fall fairly readily in the face of legislation that was hostile to them. And yet again, we see a different picture emerge from the case law. We see a picture emerge in which common law rights resilience is considerable. We see that through the strong approach to interpretation outlined in the Pearson case and the principle of legality. We see it in the notion of soft strike down that was outlined in the evidence that Lord Phillips gave to Parliament. And we see it most graphically, and admittedly most controversially, in the notion of hard strike down that was advanced, or at least hinted at, by Lord Hodge in the Mewin case. Indeed, if we press that view to its logical conclusion, then that would suggest that common law rights form an irreducible constitutional core that is enduring and durable in the face of legislation, however clear and however explicit that legislation might be. Now, of course, we don't know what a court would do in that situation, but I'll suggest in the final of these lectures that the very fact that judges like Lord Hodge have said the kinds of things that they have about the potential irreducibility of that constitutional core, about the potential inviolability of certain fundamental constitutional principles and rights, that is in itself significant and has important constitutional implications, even though we can't be certain that that kind of outcome would play out if this matter were ever to be pressed to the point of decision by a court. Before we get to that part of the series, there are two further lectures to come. Firstly, on the lessons that we can learn from the territorial constitution, and then on British membership of and departure from the European Union.